I saw, yes.
As long as we have a still from a movie up there, if we use do a slideshow on old movies.
Yes.
And we say courtesy of Warner Brothers, it's a movie from 1952. Are we okay?
So you've got a slideshow, you're doing stills from movies, and you have credit on the slide from the movie. Is it okay? Anybody want to try and answer? What did I tell you about credit? Credit doesn't protect you. It isn't necessarily okay that because you've given credit. It might help. In fact, it's likely that the studio in that context is not going to be upset, especially if you're...
They'll sell their backlog.
That's right. That's right. On the other hand, what if the copyright in the film is no longer owned by the studio? The copyright is owned by some DVD distribution company, and you haven't given credit to them. Now they might be upset about it. I mean, the trouble here is you can't assume that the person who originally just created the content is still the owner of the content. Because you can sell property, you can sell your home, you can sell your copyright, you can sell it to somebody else. Anyway, the short answer is you're probably fine because it's a fair use, because you're using it. I assume there's a photo gallery is accompanying some story about something about these movies.
Yeah, the best pirate movies ever made.
Right, there you go, okay. And you're just using it still, so you're not using the whole movie. You're using it, you're not using it a commercial way. You're not making money off it. So all these fair use factors. Yes?
Okay, so fair use question. A paparazzo shoots some public figure.
Yes.
And they're shooting them because they look different now. And that becomes...
Nick Nolte.
Or anyone. And that becomes, everyone's, blogging about it, and there's stories, there's stuff all over the web. And so that makes it fair use because it's a breaking story.
Yes.
But there's that paparazzo sold that to a agency that we do not subscribe
Corvus.
to.
Yes.
We have Getty, we have AP, but then there's a bunch of ones that we don't. Does the fact that it's, in our mind, fair use trump the fact that we're not subscribers to whatever that service is? And can we still use it to illustrate our story?
So the point is that there may be a photo that has become newsworthy that has some commercial market, a market that we haven't paid for, but does the newsworthiness of the photo outweigh the fact that we haven't paid for it? And the answer is it depends. If you have a regular pattern, a regular practice of paying for photos, the courts are going to expect you to pay for similar kinds of photos. And the fact that you don't have a relationship with the agency that owns the rights or is distributing the photo isn't going to cut any weight with the court. If you otherwise would pay, because you have an agreement with Getty, because you have an agreement with AP, even though those are not per-use agreements, those are umbrella agreements, and that's what I would argue to the court about why it's a fair use, because we don't engage in single-use licensing. But go ahead.
What if you embed the URL of that service in that photo?
Now you're not engaging in copyright infringement because you aren't making a copy.
But you're saving it. You're saving the photo, and then you're embedding the URL in
She's
the
just
photo,
making a hot link. She's
making a link.
The photo on the blog and then hot linking to it.
So that's just like attribution.
Hosting it,
that's not
actually.
No.
No, you're not.
You are hosting it.
You're not linking it.
Can you make an embed for us?
You should talk to someone in IT about that, or maybe
you shouldn't do that.
No? Okay, the same question, though, would apply to taking a screen grab off of a TV station that had that...
The Kyle Dyer situation, or any TV station. A screen grab of the content that the station is broadcasting. The answer is, the station is unlikely to engage in licensing on a single-use basis, and therefore there isn't a market for that use, and therefore your use of a screen grab in connection with some news story is likely to be fair. The problem comes up in the scenario where there is an actual market that your paper participates in or your company participates in otherwise. And the problem is paparazzi, this is the way paparazzi make their living. And if everybody could say, if you got to use the paparazzi's photos because it's newsworthy, the paparazzi would be out of business, which might not be a bad thing. But the fair use argument doesn't work if you would otherwise be willing to pay. And the answer is you are otherwise willing to pay, because you pay stringers for photos, you pay photographers for photos, you pay for photos. You just didn't pay for this photo. Well, that doesn't sound fair. So the answer is a paparazzo is entitled to payment. The fact that you see the photo on some agency site and you don't have a relationship with that agency just means you need to go get a relationship with that agency. All the way in the back.
My question is about copyright registration.
Yeah.
Can a news organization have a blanket copyright registration on everything that they produce and put on their publication?
Right. So the question is, can you have a blanket registration for everything that you produce? And the answer is yes, for a particular day or for a particular sort of time period. We now are dealing with the scenario of getting a copyright registration for content on your web, especially in the situation where there's web-only content. And the Copyright Office is not, again, the Copyright Office is based on the 1976 Act, and their regulations didn't really deal with this scenario. But we are working on it. And the way that it's being done now is you are able to register a 1 month period, I think it's a 30-day period of your website. And you have to take a grab of your website of some moment during that 30-day period, and then you burn it to a DVD or you store it. Because in order to get a copyright registration, you have to submit 2 copies. Electronically now, it's only 1 copy, but you have to. Why is the Library of Congress, the 3rd largest library in the world? Because in order to get a copyright registration, every person who got a copyright registration gave Congress 2 copies of their book. And that's the way the Library of Congress was built, from the copyright submissions. So, but in order to get a copyright registration, you have to do a submission of a specimen. The specimen is just a grab of the site, and you do this by submitting it on a DVD or some kind of digital medium. Similarly, you can register copies of the newspaper in the same way. You collect a 30-day period, a 1-week period, whatever you want to do, and you submit it to the Copyright Office and you get a registration. You can get one of these comprehensive registrations that covers everything in your publication. So the photos, the content, you have to disclaim content that you didn't create, but you don't have to worry about identifying it for the Copyright Office. You can get it that way.
Just a quick
Yes.
about this, following up on the screen grab. So a screen grab of a television show or a news story, that's fair use. What if you use...
If it's connected to a news story about that story.
Right.
Yes.
So now you've taken a series of screen grabs from the segment and put it in a slideshow. So now it's more than one.
So if you're using a series of screen grabs and you're putting it in a gallery or a slideshow, so long as that slideshow is still illustrating your news story, you're probably going to be okay. Again, I would want to make sure that the slideshow, the gallery, continues to be connected to the story, the news story, so that when it goes into the archive, the slideshow doesn't get separated from the news story. It's still illustrating the story. But then if it gets separated, now it doesn't feel like you're illustrating a news story. It feels like you're just exploiting the news station. But anyway, the slideshow doesn't change it. What matters is it newsworthy?
We used to subscribe to Bloomberg, but we no longer do. We've got a bunch of photos in our archive from Bloomberg. Can we use the old photos?
I can't give you an answer. The question is, you've got photos in your archive from a news service that you once subscribed to You no longer subscribe to it. Can you use those photos after the expiration of the agreement? And the answer is, I need to look at the agreement. I can't give you an off-the-cuff answer. It really depends on what rights were granted to you in that agreement and whether those rights end with the expiration of the agreement, or does the agreement envision that you will have continuing rights after the expiration of the agreement. It depends on what the language of the agreement is. Yes?
I know with Getty and AP, because looking at the language, most of the time, if the agreement ends, then that ends our rights to use those photos, and in some respects, they've asked us to return them.
Right. So Albert's saying that he knows with respect to AP and Getty that the rights end when the agreement expires. I would expect that. I mean, these agreements are usually written by the content creator, and their interest is in controlling the content. So.
Okay, if I can't use the paparazzi photo to illustrate
You can, you just need to pay for it.
I know, but we probably won't. So say it's on Radar Online.
Yeah.
Okay, so I'm not going to take that photo off of their site. Can I just take a screen grab of their whole page?
Is your story about Radar Online?
Yeah, I'll refer to it and link to it.
No. Referring to it is not what I meant. Is your story about Radar Online's coverage of this event?
Yes and no. It is in some respects, and I'll add.
Well, it's a very different story if you're writing about how Radar has broken the story of Paris Hilton having another affair.
I can aggregate that, sure.
As opposed to writing a story about Paris Hilton having another affair and Radar has this photo, go see it.
More the second.
Yeah, that's not. Now you're using the photo for the same purpose. You're not transforming the use. You're using it for its informational value.
So if I just aggregated it and said they broke it, here's their page.
Yes, yes.
That's okay.
Yes.
You can link to their page, but you can't use the image.
But no, but I'd be using the image because I'd be doing a screen tag of their page.
Yeah.
And say that's okay.
Yeah, if what you're doing is merely saying, Radar's broken the story about Paris Hilton, and here is the image of what's on Radar Online,
What's on their page.
what's on their page, and suppose that you make that image a hot link so that you click on the image and go right through to their website. That feels much more fair to me because it's much more like the headline in the first paragraph.
It would be a screen grab photo of their page with that good photo on it.
Yeah, okay, but now is the point of this to convey the photo, or is the point of this to convey Radar's story?
Photo.
I'm not liking that. I'm feeling that's more exploitive. Yeah, I know. The way is to pay for it, but yes.
We have Facebook comments on the bottom of all our stories.
Yes.
A person makes a comment about that story, but the comments are served up by Facebook.
Right.
And we sometimes republish the comments
Right.
on that story
Right.
in the paper. Who owns that comment? The original person who posted it, or Facebook, or we?
Content is owned by the original creator. So the person who wrote the comment is the owner of the comment. Your ability to get the comment is a function of your access to Facebook, and your access to Facebook is controlled by the terms of use of the Facebook site, and Facebook's terms of use limit republication of content on the Facebook page. Whether Facebook is ever going to sue you for this is a different question. The probable outcome here is content. Do you have an agreement with Facebook to use this comment?
In terms of use.
Yeah, but you're sharing. What's happening is you're getting a feed from Facebook of the comments that are posted about your story because people like it, or you get a feedback to your. And in that scenario, Facebook is consenting to your use. And when that happens, you're okay. At least you vis-a-vis Facebook is okay. You vis-a-vis the commenter, they probably need to have a better understanding of Facebook to understand that what they post on Facebook is never private, despite their privacy settings. But what I will tell you is that when you get a complaint from the person who posted the comment, the safest course is to take it down, because if you take it down, you're protected by something called Section 230 of the Communications Decency Act. But until you And until you get that complaint, you don't have to take it down. But if you do get a complaint, the safest course is to take it down.
Sometimes with those comments, they'll take a selection of those comments and put them in print.
Mm-hmm.
You know, this is a hot story, this is
Yes.
what people are saying about it.
Yes.
So that would be, is that transformative?
Is it transformative to take it from the online scenario and print it in the newspaper? Does that feel like a new use?
No, to gather it in the,
To aggregate it?
yeah.
If your point is to write a story about how this particular issue is trending,
Right.
and here are the comments that illustrate, that show that it is trending up. That's a story about the trend, the fact that it has become newsworthy, as opposed to merely regurgitating the comments. That becomes transformative. And so that would be where I would say you've got a fair use to do that. But if what you're doing is simply, there's a story that's causing lots of buzz, and all you're doing is simply republishing the buzz. You're putting either online or in print, it doesn't matter. That difference, online versus print, is not transformative. But if you are simply republishing the comment for the value of the comment, it's not transformative. You're simply redistributing the content.
Yeah.
Yeah, well, there's a risk in the assessment here. She says we do that all the time. And the answer is you do that all the time, and it probably is always a copyright infringement, but are you going to get sued?
Okay, but also sometimes it's stuff that's not even Facebook comments attached to a blog or an online story. It's just, some of us have popular social media pages, and it's just comments being grabbed from our social pages.
Okay, so these are comments that are being posted onto a clearly identifiable newspaper-associated page. In that context, because of the nature of the Facebook page, you can argue that there's an implied consent for your republication of that content. People ought to know that if they post a comment on a newspaper columnist identified as newspaper columnist page, that their content may get used. I mean, that, and you probably, a lawyer in me says, and you should tell them that you might use their content. But this is all sort of, what did they think? In this world, if they're posting a comment on a public figure or celebrity, whatever, if they're posting it in this way, I think most people would expect that their content is going to get republished somewhere, especially if you're giving it to a newspaper, for God's sake.
I got a Facebook question. No, I'm not about someone commenting on a story, but say someone posts a comment on Facebook. Here's an example. There was a shooting in Seal Beach, and they created a big memorial. There's all kinds of comments about it.
Yeah.
Is that fair game to use those comments on Facebook?
Where are they posting the comments?
In a news story.
So it's a link through to your story.
No, it's like when you're gathering information. I see this in lots of stories. They'll say, so-and-so said this on Facebook or on Twitter. You're referring to like a comment that they made in public, not to you, but they posted it in a public place.
Right. Okay, so...
Wasn't it even they created a whole nother Facebook page?
Yeah,
that had nothing to do with us. That was like the Seal Beach Memorial page that we went to and took.
Is that all right to publish what they said?
So this is an important distinction between merely republishing the content and quoting the content. If you're quoting the content in the context of a news story, very transformative, now we're doing what we always do in our news stories. We quote people. If that's the use that you're engaging in, it's very likely to be fair use. But if what you're doing is, instead of putting it into the news story, you're simply republishing it as sort of the source material. I mean, newspapers today, lots of news media today, want to post the source documents, the original documents. So we'll let readers see what we're doing. That's great from a news point of view, but there are copyright issues around that, because now we're simply republishing for the same purpose as the original author the content. We do the fair use analysis in the same way, and we probably get to fair use again even though we're simply republishing, we're not commenting on the stories, we're not building something new, we're just redistributing. But it feels different. I can't put a finger on why it's different. I think you will ultimately be okay if it's still newsworthy. I mean, so there's this new Facebook page for the Seal Beach Memorial. There's all kinds of comments being posted on it. And on your story about the Facebook page, the Seal Beach Memorial Facebook page, or the community outpouring, and among the things that has happened is a Facebook page has been set up. And next to it, as a sidebar, you've got sort of republishing of comments posted there. Maybe even you do a screen grab and you take a picture of the page and you show the content there. That feels very fair use to me, as opposed to building a feed from the Facebook page that's flowing real-time content that's being posted from on Facebook, on that Facebook page, onto your page. That feels different. That feels unfair to me.
Can you talk a little bit about what we can and cannot use off of an individual's Facebook page?
Right. So this may have less to do with copyright and more to do with privacy. So the question is, what can talk about what you can use from an individual's Facebook page. The first and the hallmark of what you can use is a function of how public is that person's Facebook page. If the person has Ashton Kutcher size friends, millions of friends, it's a public website, even though it's technically not, because you have to be a friend in order to get access to the page. I don't know, 1 million is easy, that's public. 1,000 feels kind of public to me. Below 1,000, I'm not so sure. My daughter has like 800 friends, and I made her sign a contract. I mean, I'm a lawyer. The contract for her laptop says that she can only friend people that she actually knows. And she insists that she knows all 800 people. So the first question is, how public is that site? Next question is, how did you get access? Did you get access by impersonating a friend? So there is somebody who is newsworthy, a kid has been shot, high school shooting. The kid has a Facebook page. Did you get access to the page by logging in as someone you are not? Or separately, differently, did you get access to the page because someone you are not actually logged in for you, and you looked over their shoulder and you looked at what they could see? That's the same as the person turning around and telling you what they can see on the website. That's okay. But if you impersonate the person who has access to the page, you use some mechanism by which you get access to the target's page through some somewhat deceptive means, it's not okay.
Send a friend request, and then somebody accepts it.
Right. If they accept the friend request and you have not impersonated someone you are not when you made the friend request, then you're okay. Then you haven't engaged in any deceptive conduct. It gets dicier when we go outside those safe places. When we go into, okay, I send a friend request from an email address. It's not an email address that's false, but it is an email address that doesn't identify that I'm a newspaper reporter. It's some pseudonym, Gmail address. If the person accepts the friend request, does that feel like you are deceiving them? SBJ may say yes. On the other hand, caveat emptor, the person who accepted the friend request should have known better. They should have followed my rule with my daughter. You only accept friend requests from people you know. The answer is, if you, having gotten access to the Facebook page, you do something with the content that's available on that site that really hurts somebody's feelings, now the person whose feelings have been hurt can make a big to-do about how you were deceptive in getting access to the page.
A lot of times what is being used off of Facebook pages are pictures.
Yes.
Most of the time it's a case of someone's dead.
Yes.
Either it's that person's dead or that person is accused of making someone dead.
Right.
At what point, I mean, if it's a public, they don't have any privacy settings set, it's like, here's
Right.
my life.
Right. So what if, again, now so the question is, usually we take photos from other people's Facebook pages, and usually it's because there's some news value in those photos. And then what can we do? The first point, go back to the beginning. The fact that it's on Facebook does not mean that the person whose Facebook page it is the owner of the copyright. It is likely, in fact, that the owner of the copyright in the photos is not the person whose Facebook page it is. That being said, if the photo is connected to a newsworthy event, it is more likely than not that it will be fair use to use the content without permission. Although in the analysis of the fair use balance, the court may start, the courts haven't done this yet, but they may start worrying about how did you get access to that photo. If it's a completely public page, or if it's a public page that doesn't have real good privacy settings, courts are beginning to understand that that's just like being on the internet, being on the free and available internet, and so they may not be worried about it. But if you break through some privacy setting, the fact that the photo was newsworthy is likely to result in a fair use outcome, but I worry about this. I mean, fair use is about equity. It's about fairness. Is it fair to break into somebody's Facebook or social media site where they have intentionally tried to keep the content on the page private? I mean, think about this. I mean, we need to understand that just because we are in the news business, we are human beings. And the way plaintiffs' attorneys get us to pay large amounts of money is when we behave inhumanely, when we don't have decency in the way we treat other people. So we need to hesitate when there may be a real good reason to break into somebody's Facebook or any social media site. Good example, Ashley Madison. Everybody know what Ashley Madison is? It's a site where you can go have an affair. A newspaper was able to ascertain that a public official was surfing on Ashley Madison. The profile of, God knows how this happened. The newspaper investigative reporter got a tip, and the investigative reporter figured, and then logged in and signed up for Ashley Madison, and was able to look at this public official's profile page and was able to ascertain who was behind that profile page, and then published a story about this public official making himself available for extramarital affairs. And completely in violation of the terms of use of the Ashley Madison site. But it's newsworthy. And as long as it feels like the public official should have known better, the courts are likely to say that the fact that you breached Ashley Madison's terms of use and the fact that you published private information is not actionable because it's newsworthy. But if your use of the content that you got through deceptive means is gratuitous, is unnecessary to the story, then the courts are likely to say you invaded the privacy of that person and they're entitled to some money for it. It's about who's wearing the white hat, who's the good guy and who's the bad guy. But yes.
To move away from electronic, to go old school here for a minute, we get photos all the time from people when we go to their house, right? They get out
yes.
Do we need to worry? I mean, all of this stuff. Do we need to worry about all those photos?
Well, I mean, this is the Katy Perry scenario. I mean, I keep getting feedback.
One thing that we did, this was years ago, created a little release thing that you could take with you, so that if somebody releases a photo to you when you go to their house,
We never got that.
you can have them sign it, and then we have
the better scenario is usually your reporters now are equipped with video cameras because you've got to do multimedia. Why can't you videotape them giving you the photo? Because now we've got documentation of their permission.
But doesn't that go back to what you're saying?
Right.
The photos,
not necessarily the owner, and this is the risk, yes. And I understand that it feels like this is the way we've always done business, and this guy is up there telling us that the way we've always done business is likely to lead to a lawsuit. And the answer is yes, it will. The world has changed. We've got plaintiffs' attorneys out there who sue over this kind of stuff. I mean, we've got lawsuits based on high school yearbook photos. It is regularly, I mean, this is very old school, that when somebody becomes newsworthy, we go back to the high school yearbook and we grab the photo out of the high school yearbook, and we use that as the little mugshot, whatever, for the story. And then we get commercial photographers who say, I took that photo, pay me money. Where
about what guidelines we should use when something is newsworthy?
Well, this is what I will always do, what I will always argue for you is when your use is connected to a news story, it is fair use under the First Amendment. You are engaging in highly transformative use of this content, and therefore you should not have to pay. But the moment you ask me to make that argument, you're spending money. And the point of this exercise was to get you out of the business of paying money for this kind of content. The safest way to avoid paying money is to get permission. If you can get permission, great. If you can't get permission, we're into a risk analysis. We're into how likely is it that they're going to sue you? Unlikely, likely. If it is likely, can we do something that reduces the damage? Can we avoid the lawsuit by some way? There are, I mean, we can, but what I'm hoping is that having heard this talk and understanding that the world has changed, you now raise your hand when this issue comes up and you have a conversation with people, and you guys, before you even get to me, you have this discussion. Are we going to get sued? Who would sue us? Is it likely that we would get sued? How much is the person going to demand? Can we pay $25 to make this go away? I want you to have these conversations. I want you to stop and think before you post. But at the end of the day, you've got to put out a newspaper. You've got to get the big gaping hole filled. And if you have content that is newsworthy, that you didn't get permission for, that is content that you are likely to get sued over, and your editors decide that's a risk that comes with the terrain. That's the cost of doing business. We will take that risk. More power to you. And I'll stand up in court and say the First Amendment protects what you did. But you want to think about it.
It's something, for those of you who don't know me, I'm Jim Grothberg. I'm one of Chris's law partners. If I got a call from a reporter on Deadline, said, you know, we have this story about this kid who was killed in a traffic accident, and I'm standing at the kid's home, and there's this, I'm looking through the family photo albums, and I'm trying to pick a picture. One thing I would do was say, can you find out if there's a picture that was taken by mom, as opposed to one that was taken by a professional photographer for school, you know, the annual school photos. I'd be much more comfortable with the picture taken by mom, particularly if mom's there giving it to you, or even Uncle Charlie. Then
this is the risk assessment. You are more likely to get sued by a commercial photographer than a non-commercial photographer. You're more likely to get sued by someone who's in the business as opposed to someone who's not. And you're very less likely to get sued by someone who took the photo and then gave it to you. If mom took the photo and mom gives you the photo, or mom's there when dad's showing you the album, there's all kinds of arguments about implied consent.
Well, we also had a situation here, I believe, where it was a teenager that had some photos taken in a bathing suit.
Oh, yeah. Now, mom doesn't want your photo.
Well, the mom came back and complained because she said, how did you get these? Well, the aunt was at the house when the reporter was there and gave them the picture.
Right. So, then we get into this question of apparent consent, apparent authority to give consent. If the aunt is there and it looks like the aunt has the authority, the power to give consent, you're entitled to rely upon that consent. But if it looks like the person who's giving you consent is a stranger or is not a family member or doesn't have parental authority, the permission they give you is not effective. But I'm happy to stay, but we're winding down and the cameraman needs to wrap up.
Thank you.
Thank you.